Welcome everyone. I'm Frances Lannon, Principal of the College, and I'm so pleased that you're able to be with us this evening as we explore the riveting topic of law and Hollywood. I'm really delighted to welcome again to LMH visiting fellows Don Howarth and Suzelle Smith. They are founding partners of the Los Angeles law firm Howarth and Smith. Suzelle and Don have a formidable reputation as successful trial lawyers in complex and high-profile cases. These cases have often involved powerful international players. By powerful, if I can just give you a few examples, I have in mind the tobacco industry, the Vatican, and state sponsors of terrorism. So I think you'll see from this that Suzelle and Don do not lack courage. And moreover, they usually win. They're known to us, to many of us here, through previous lectures in earlier years on a very wide variety of topics involving the law. Suzelle and Don are also known to some in this audience who have been lucky enough to be part of their graduate internship program in their firm in Los Angeles. So I'm conscious that I'm welcoming tonight quite a few alumni of LMH, and actually quite a few LMH alumni of Howarth and Smith. Suzelle and Don are expert speakers on today's topic, law and Hollywood, having successfully sued a number of studios. Again, not exactly small players. Paramount, Universal, and Warner Brothers, for example, for a number of writers and directors and actors. And their clients include Olivia de Havilland and Robert Towne. I'm also greatly honoured to welcome for the first time to LMH Professor Thomas Stepanovich. Professor Stepanovich is the William H. Webster Chair in Dispute Resolution and Professor of Law at Pepperdine University. He's also the Academic Director of the outstanding Strauss Institute for Dispute Resolution. Professor Stepanovich is a major international authority on arbitration and dispute resolution, with many groundbreaking and much cited publications. Now, Tom is currently writing a book about law and Hollywood, which will include Olivia de Havilland and Bette Davis. So I think you can see that we are privileged indeed to have such expert, closely involved and renowned speakers this evening on our topic, law and Hollywood. Suzelle and Don and Tom, welcome.
Thank you very much, Dr. Lanning. It's a pleasure to be here at Lady Margaret Hall for the first time. And I have to say, I felt your warmth and hospitality over the last day or so. I also extend my appreciation to my dear friends Don and Suzelle for allowing me to take so much of their valuable time here today to tell you a story about a remarkable woman and a court case, but among other things, the story of a relationship between a young woman, scarcely older than many of the people in this room, and a studio in the golden age of Hollywood. Now, every so often, you'll hear someone, some entertainer, a rock musician, a professional wrestler, extend their appreciation to none other than Olivia de Havilland, who happens to be 97 years old and living in Paris these days. She also happens to be a star of one of the great American films, Gone with the Wind, and a two-time Oscar winner. You might think of her in terms of actresses like Meryl Streep or her contemporary Bette Davis. Olivia's name is, however, best known in connection, perhaps, at least in legal circles, with a court case that hails from World War II. Now, when you hear the name de Havilland, or more specifically Havilland, you probably think of a bomber from that era. As it happens, there's a connection there because Olivia's family hails from Jersey, and so she's related to the Aircraft Corporation. Nevertheless, Olivia was American. Born in Tokyo, but as a young girl was brought to the United States by her mother. Little did she know that as a teenager she would become part of the studio system and ultimately give her name to a very important court case. Now, when Olivia arrived in Hollywood, she was a precocious 18-year-old, and her destination was Warner Brothers, which was a scrappy, risk-taking factory for film, founded by four sons of a Polish shoemaker. Jack Warner was the head of the studio. Harry Warner was the CEO in New York. Now, of course, this was the studio that was known as the studio that ripped its stories from the headlines. Honestly, this worked out quite well because this meant they could make low-budget gangster pictures, which could be done very, very inexpensively and very quickly with people like Edward G. Robinson, Paul Muni, and James Cagney. Now, Warner Brothers was part of a mature oligopoly, a vertically integrated system of production and distribution that dominated the motion picture market. The system was factory-based. It had a division of labor, distinct relations of power, which not only permitted but virtually demanded a degree of struggle and negotiation in the filmmaking process. Now, you had struggle and negotiation because on the one hand, studios needed to differentiate their product. They needed innovation from time to time. And they also depend on the talents and personalities of key creative personnel. The star, the Hollywood star, was the keystone of this edifice. And how style was tied, their brand was tied to individual personalities. So you have the movie star that's the keystone of this process, but at the same time, their role in the process was very circumscribed, and there were many, many other people on the team. So occasionally you had this constant interplay, this constant struggle between, on the one hand, the creative talent, and on the other hand, the business interests of the studio. And Olivia's own career is part of this archetypal struggle, pitting the interests of businesses seeking to make a profit through the management of this extraordinarily complex creative process against the agendas of individuals who seek to maximize, in some cases, their own economic gain, and in the case of Olivia de Havilland, their professional reputation and their creative opportunities. Now, Olivia, it must be understood, and you'll hear later, is an extraordinarily precocious young woman as she's emerging from high school. Ambitious, self-possessed, confident. She saw Catherine Cornell in a stage production and decided, that's who I want to be. I want to be a stage actress, a famous, accomplished stage actress. Well, fresh out of high school, she somehow managed to work her way into Max Reinhardt's nationally known production of Midsummer Night's Dream, which was going to be shown at the Hollywood Bowl. There's a lot of attention on this production. She put herself in what, in Hollywood parlance, we would call the 42nd Street position, because she wasn't the understudy, but she was the understudy to the understudy for Gloria Stewart, a well-known actress who was to play Hermia in Shakespeare's Midsummer Night's Dream. As it happened, the studio called back first the understudy and then Gloria Stewart. So Olivia had to step up. She was bright enough to know what she didn't know, and she followed Reinhardt's recommendations, or as she called him, Herr Professor Doctor's recommendations, to a T. So with the help of this Svengali, Olivia successfully managed not only the Hollywood Bowl production, but she got herself an invitation to star as Hermia in the Warner Brothers film. She was signed to a short-term contract for about $250 a week. Now that's a lot of money for a teenager in the middle of the Depression. Humphrey Bogart, who was then an accomplished Broadway star, had come in a few months earlier for $500 a week. So she's in wonderful company. Well, this was a magical experience. Here she was, the star of one of Warner Brothers' big prestige productions. She said, this Hollywood stuff may be okay, may be an effective substitute for being a stage actress. Well, after Midsummer Night's Dream, the dream ended. And while she had many, many wonderful opportunities, they tended to fall into a sameness, as you'll see. The linchpin, however, what we need to first mention is the linchpin of studio control. This was the system of option contracts. Up to 7 years of one-year options, which they would structure to give themselves control over the creative talent. So in other words, they would give you a contract 1 year at a time. They always had the option of letting you go, but could hold you for up to 7 years. Now, they were aided by a California statute, Section 2855 of the California Code, which is totally unique, and which they managed to get passed through the California legislature. And this allowed them to hold people for 7 years or longer. And the reason why there was at least the possibility of holding people for more than 7 years was the suspension clause. It said, if you're an actor and you do not accept a role that Warner Brothers wants to give you, then they can put you on suspension. For the period of the picture, they'll put someone else in your position. You're not getting paid, and what's more, they can tack the suspension period on to the end of your contract. So you have to give them 7 years of actual work, actual labor under this system. So this was the keystone of the system. Now, there were many stars that were fine with the system. They said they had the perks, the prestige, etc. And then there were stars like Jimmy Cagney, who found a way to deal with the system. Just briefly, by way of contrast, Jimmy Cagney was, of course, the epitome of the Warner Brothers male star in the early 30s. I want to ask our young people, how many of you have ever seen a Jimmy Cagney film? Do you know who I'm talking about? Okay, I see some young and some not so young people who are raising their hands. Now all of a sudden I'm faced with blank stares when I talk about these actors. It blows my mind, even in my own family. Some of the younger ones, not Laura, my youngest daughter, don't know these stars. Cagney was the perfect client if you needed to negotiate with a studio, because on one level he didn't care. He had what we call in negotiating parlance the greatest BATNA, the greatest alternative to a negotiated agreement that you could possibly have. He didn't care. He would be willing to walk away. His brother was his agent, and the Cagney boys pitted themselves in constant struggles against the Warner Brothers. And Cagney was every bit as tough as his on-screen persona. He had to be. He was trained by a mother who carried around a bullwhip and taught him how to box. So an extraordinarily tough character. And Cagney, whenever negotiation time came around, which was about once every year or two, the Warner Brothers dreaded seeing Jimmy Cagney show up. Now, Olivia de Havilland signed a long-term contract which provided the studio with a series of options for up to 7 years. She was starting at $500 a week, which sounded pretty good. If she could hold on until the end, she would make $2,500 a week, which sounds like a lot until you begin comparing it to some of the numbers that they were later throwing around. So what we have here is a factory system. It has a male ethos, very strongly dominated by male stars. And star is a very important concept. If you look at the forms, you go into the Warner's files, as I have, you look at all these thousands of pages of production logs, they have the name of the picture, and then they have the name of a single star. That was the concept. Now, in Olivia's case, who was that star? Well, for at least 8 of the pictures she made at Warner Brothers, it was Errol Flynn. And she essentially, as we'll see later on, she was the female half of the Flynn de Havilland duo. But Flynn was the star. And in fact, after the great success of Captain Blood in Charge of the Light Brigade, their first couple of pictures, Jack Warner, uncharacteristically and dramatically, literally tore up Errol Flynn's contract and signed him to a long-term deal beginning at $2,250 a week. Now remember, this is what Olivia was hoping to make some years hence, 6 or 7 years hence. She was still at $500, and this is the person she's working with. Now, Bette Davis simultaneously is a very different personality. Here she is on a male-dominated lot. She was fighting, swimming upstream against this system. And she had a breakout role in Of Human Bondage, and finally began to get parts she could sink her teeth into. She got a picture called Dangerous, for which she received an Academy Award. However, strangely, this did not improve her status or the pictures she was getting at Warner Brothers. And when Jack Warner refused to sign her out, loan her out to RKO, another studio, for another picture, which she really wanted, she took a 6-week layoff, not something you do unilaterally. More than that, she talked to the press. And finally, she spirited herself away to guess where? England, where a producer, an independent producer, had promised her a series of pictures. Well, no sooner had she arrived in England than Jack Warner, who's on honeymoon with his new bride in Europe, says, I'm going to London, I'm going to lawyer up, I'm going to get her back. And they subsequently sought and received an injunction. However, at the time, and I've seen the telegram traffic going on behind the scenes, there were some worries about that suspension clause and just how effective it would be. And at that time, the lawyers and the higher personnel at Warner Brothers were a bit worried about it. Anyway, meanwhile, Olivia de Havilland is watching Bette Davis lose this court case, but she also saw what happened afterwards. Bette Davis came back, and curiously, life began to improve for her. She got one of the most notable pictures that Warner Brothers had created up to that time, Jezebel, and won her second Academy Award as a result of that in that William Wyler directed film. However, Olivia is still struggling on playing arm candy for Errol Flynn, and she's just about at the end of her rope when she gets the opportunity to become Melanie in David O. Selznick's production of Gone with the Wind. This was the biggest thing that had ever hit Hollywood. Bette Davis had hoped to be Scarlett O'Hara. Every actress in Hollywood was thinking about these parts. Olivia wanted to focus on the character of Melanie, and we'll see a clip of her in a few minutes. And indeed, after much cajoling, after the indirect approach, which, by the way, Olivia is very good at. If I had more time, I could tell you stories about how she would work with different people, different technical artists, to try to make the most of every project. But in the case of Gone with the Wind, it was really going to Jack Warner's wife, his new wife, Anne, who eventually persuaded Jack to let Olivia go and come to Gone with the Wind. Well, of course, that was a mountaintop experience. Here she was working for one of the most creative and intense producers in Hollywood, David Selznick, in one of the great cinematic adventures that anyone ever had. And yet, even before Gone with the Wind premiered and she came back to the studio, she could see the handwriting on the wall. Jack Warner was not going to give an inch in terms of the productions that she was in. So she again consigned herself to what was largely a series of pretty dreary and monotonous roles. She did have one great experience in Hold Back the Dawn, which she did on a loan out to Paramount. And she got an Oscar nomination, once again, as she did for Gone with the Wind. But things were bad at Warner Brothers. So we come to 1943. Jimmy Cagney has gone independent. So has Edward G. Robinson. Bette Davis has her own production company within Warner's. What about de Havilland? She's still doing the same roles, but at least, although she keeps getting suspended because she won't take the roles they're giving her, she thinks at least it's almost over by 1943. She gets to the end of her final option contract, starts to leave, and they send her another part, and they say, see you next week in your new film. She said, what do you mean? My contract's at an end. They said, read the suspension clause. You still owe us a few more months. At this point, she consulted her agents. They referred her to Martin Gang, a respected Hollywood attorney. He was the Don and Suzelle of his day. And they sued Warner Brothers and sought a judgment that the suspension clause should not be enforced because it violated the 7-year statute in California. You could not extend the 7 years, in other words, by any means. And sure enough, they went and succeeded. Now, this is a big deal for a young woman in her mid-20s. To bring this suit, have to go all the way to the Court of Appeals. And for months, she was not only without a contract, but Warner's had sent out letters to, as she said, every production company in Hollywood and a few that did not exist. But ultimately, she had a court victory that is still resounding. It was one of the nails in the coffin of the studio system, because no longer could the studio use this as leverage. What's very interesting is, although Cagney and Davis both got significant creative control themselves, they were never successful. They couldn't make commercially successful pictures that they wanted to make. Their success all occurred at Warner Brothers. For Olivia, however, she had to break out of the environment that to her was, as she said to me, part stock company and part prison. So she left. She got an arrangement with Paramount. She did, among others, 3 pictures in the next 4 years that have become part of cinema history. The Snake Pit, To Each His Own, and The Heiress. She was nominated 3 times in 4 years for Best Actress. She won 2 Academy Awards and the New York Film Critics Circle Award for the work that she did within 4 years of leaving Warner Brothers Studio. Today, the de Havilland case is still cited. As I said, it was a watershed event in Hollywood history. And today, production is handled very differently. It's handled by independent production companies, as often as not put together by agents, who themselves, by the way, have been called into tow by the de Havilland decision. The studios today rent space. If you go to most of the major studios, it's not their productions that are going on, it's independent productions. Warner's continues, as you know, to this day, as part of a major media conglomerate. And as I say, the statute continues to be a significant factor in the continuing conflict between capital and labor in the entertainment history. Curiously, they've added a second part to the statute, which deals with, essentially focused on record companies. And what it says is, although the 7 years is still in place, it says that if an entertainer, let's say a rock band or some other musician, does not complete the number of projects that they committed to do within the 7 years, and they attempt to leave the contractual arrangement, their studio can sue them for not having completed their contractual requirements. What they keep saying is, we need another Olivia de Havilland to vindicate our rights against studios in this area. However, I think for a variety of reasons on both sides, these cases always get settled. Well, I've probably taken more time than I should have, but I hope you've learned a little bit about an important event in Hollywood history. We're going to talk a little bit more about that, and also about this magnificent woman, Olivia de Havilland, who we're all privileged to know. Thank you.
Well, it's very nice to be back in Oxford in such weather. When my son first arrived at Lady Margaret Hall, he had a couple of weeks of different sort of weather that you're more familiar with. And he told me, he said, "Dad, if you were told that you had 3 days to live here, you'd spend most of it moving." You know, so But it's been gorgeous since we've been back, and we're very pleased to be here. What I would like to do is put this history that Tom Stepanovich has given you so well into a little bit of the legal context so that you see where it fits in this great fabric of the law. Because we're dealing with that corner of the fabric that has to do with contracts. And as the law students here could tell you, if you think about contracts and breach or breaking contracts, there are generally two remedies available for a breach of contract. One is a damage remedy, where you sue for damages, for money damages. The other remedy is specific performance. He agreed to transfer his home to me, and now he's broken the contract. I want you, the court, to compel him to perform, to give me the home. So those two remedies were generally available since the time of man runneth not to the contrary in contract law. What built over the years here in England was an exception to that it was improper for the courts to compel specific performance, injunctions, requirements to work, and so forth, in contract cases that involved personal service contracts. Now, the cases developed on this over time, but essentially focused on three elements. When a court would compel specific performance of a personal service contract, anything from an actor, entertainer to a maid, a personal service contract, there arose, and the litigants time and again raised the issue of, well, isn't this really at the end of the day a form of involuntary servitude? And that policy issue was very important to the courts. Another issue in the courts resisting the notion of specific performance of personal service contracts was the difficulty with enforcement. If you think about requiring an actor to go ahead and act, what kind of a performance are we going to get if the actor is doing it under compulsion of law? Or an entertainer to entertain? How are you going to take the position that he's not really entertaining? He's been required and he's going through the motions. That was a second policy reason behind this rule. And a third and important one, and I think the one that resulted in what I'm going to call the California Compromise, the legislation that Tom discussed, was the notion that the law resists restraining the individual's ability to bargain indefinitely. If you don't allow the individual to reset his bargaining rights, then you don't allow him over time, as his reputation or abilities improve, to capture his marginal product. And the law traditionally has resisted the notion, in this and other contexts, that you can restrain that perpetually. You see that in other areas of the law, this notion that you can't let the economics of the time be locked in entirely. In England, you had the Tulhalson case in, in about 1850, I think, in which a very wealthy merchant entailed his, it was 1805, it was earlier. He entailed his estate for 9 generations, so that the estate would not leave his family. They could not alienate it for 9 generations. And actually the House of Lords sustained the entailment, but it was so popular and so unpopular what he'd done in 1805 that Parliament actually passed an act, the Tulhalson Act, revoking this and limiting the ability to entail or to tie up the property for more than the life of one person who was yet alive plus 21 years. We have a parallel, and you have a parallel, in what we call the rule against perpetuities. The rule against perpetuities is probably best illustrated by Benjamin Franklin's case. So Benjamin Franklin, who died in 1879, I think, left 2 trusts in perpetuity, each with $1,000, which was a lot more money in 1879 than it is today. And the 2 trusts were for the benefit of Boston, where he'd spent much of his life, and Philadelphia. And the idea was that they were to accumulate income for 100 years and at the end of 100 years, distribute the income and keep the principal of $1,000, and then do it all over again forever. And thus Franklin thought to benefit these two cities. And that was ultimately forestalled. He calculated, I think he was fascinated at that point by compound interest and how the interest would accumulate and accumulate given the right rates over time. The courts, in ruling on that and similar attempts in the United States, reasoned again that if we were to allow this, like your Tell-Halson case, eventually the entire property of the world could be drawn in by the vortex of this perpetual estate or trust. And so generally we have the rule against perpetuities that restrict this. Now there have been inroads in trust and estate law and so forth into this. And as all of these principles in law, none of them, the law's resistance, for example, to restrain the ability of individuals to break out of a contract or a bargaining situation, none of those are absolutes. Like all principles in the law, they move in ether over a time, and then they encounter other principles, and they compromise, and the law, over time, with changes and evolution, accommodates different interests. So don't answer an exam question that law will never allow perpetuities or the bargaining must always be reset. It won't happen. But it is a theme. It is one of the strands in that fabric that is consistent throughout the law. So when California adopted this statute allowing the studios to tie up the actors for 7 years, it was a compromise statute against the law that had developed that said you can't compel any specific performance on these contracts for individual personal service contracts because that's what they were. And so when Mr. Havilland, who had watched Bette Davis's case, which you heard about, she lost badly. It was, they said, like watching a train wreck in slow motion to watch that case. And she watched that, and it ended very badly. And Mr. Havilland, as Tom so nicely put in context to you, you know, my accountant tells me there are three kinds of people in the world. I think he said those who can count and those who can't. Lawyers generally can't, but Mr. Havilland could, and she could count to 7. And so when it got to 7, she said, "I'm out of here," which then fulminated the case. Gang, Tyrer, and Brown is now her firm, still in existence, and Martin Gang was outstanding lawyer of his day. But when she got that case and limited it to the 7 years, it was already building on a compromise because of this resistance in the law to allow people not to have their bargaining power reset to some fair current level. As I've said, it's common in other themes in the law and in other cultures. Some of you may know the ancient rule in Israel of the year of the Jubilee. The year of the Jubilee, 7 years was a sabbatical, 7 times 7, 49 years. The 50th year was the year of the Jubilee. And in this Bedouin society, without structures, nothing like this that we're in today, this beautiful new theater, but mostly people living in tents, over time, individuals would accumulate wealth and they would accumulate land. And in the year of the Jubilee, after 50 years, everything reverted back to the tribe and it was redistributed. Indentured servitude ended at 50 years. Debts were forgiven after 50 years. So it was another example in another society of the same principles at work, that if we allow the economic advantage to go on forever without allowing this coming to the bargaining table and a resetting of the interest, then in the end that is going to be productive of mischief. It's interesting, and I'll use this example that it appears, I'll use one example in that regard, this concept of fairness in bargaining and recognition that bargaining and economic deals, which is what a contract is at base, because the law doesn't require us to enter into contracts, it permits us to create rules by agreement or a contract. But the principle of fairness in that, and that it has to be fair to more than the players, seems to extend beyond just human beings. In 2010, the University of Texas did what's now a very famous behavioral study on chimpanzees. And the researchers there in Texas were able to train the chimpanzees quite readily to enter into a bargaining system, or a system of contracts, whereby they exchange two brightly colored pebbles for a grape. Now, a grape is apparently a delicacy to a chimpanzee. And so they were trained readily to exchange these two brightly colored pebbles and to get back one grape. After the researchers had them all very well trained, they brought them in pairs. And to one of the pair, they would give a grape for only one pebble. When the second chimpanzee in the pair saw this, they refused to trade at all and just held on to their pebble, even though they wanted the grape. What's more, when they then began giving to some pairs the grape without requiring any pebbles whatsoever, the other chimp, many of them, actually a statistically significant number of them, actually threw the pebbles back in the face of the researchers, threw them down, wouldn't eat the grapes, wouldn't enter into the trade at all. So it is, I think, an example of the recognition that the bargaining, there has to be a sense of fairness to the bargaining part. There's, by the way, a parallel to that. I know Gary Hall knows this, but others probably do, in the scriptures, in the parable of the laborers and the vineyard, which I think is in Matthew 19, is it? No, you can check me on that. I can't see it in the light. But in any event, the laborers in the vineyard are a similar example of the chimpanzees, where the resistance to people who had agreed to one thing was overwhelmed by the fact that others were getting a better deal at the end. So this notion, this concept in the law that you can't restrain forever. You can allow a short-term contract. You can't restrain forever an individual's ability to come back to the table and get the benefit of their marginal product is one that you see popping up a little bit like that game the kids play, whack-a-mole. You know, you hit it over there and it pops up over here, and you hit it over there and it pops up over there. And the 7-year statute, I think, was a compromise with that concept. And Tom is right that the issue is not a dead one at all. In the case of the musicians, the bands, recording artists, and so forth, the notion is they're not restricted beyond the 7 years, but they have to produce a certain number of recordings under their contracts. And so we have musicians coming to us saying the number that they're requiring me is such that they know it would take 20 years or 14 years to do it. All but the greatest stars are not going to be able to do this in the time required. You don't have the creative ability to keep that going. So it's another attempt in the fecund field of the law. You think life will find a way, law will find a way. Over here, an effort to constrain and tie them up, and then the resistance. And when the resistance comes, what do they cite? They cite that unseen guest at every free agent's dinner in Hollywood. They cite the Olivia de Havilland case. So we, as Suzelle will tell you, are very proud to have been able to represent and know Ms. de Havilland. She has certainly received recognition in the movie industry, but as a person, she was responsible, as Tom said, at a very young age for something that was very dramatic and that tied on to major themes in the law, which are a part of contract law and a part of the general principle that we see in a law that we can't let it all get tied up for too long, or it comes off the hinges, the bargaining doesn't make sense, and the system breaks down. That's what the de Havilland case at base is about, and that, I hope, puts it into a little bit of a historical context for you. So at that point, I'm going to turn it over to my partner, Suzelle Smith, who will tell you what kind of a woman it took to stand up and do this at age 27. Thank you very much.
Good evening. It's been my great privilege to know Olivia de Havilland for over 2 decades. She will be, as you've heard, 97 years young on July 1st of this year. Now, Tom asked a question about how many people had seen Olivia in some movie, I think, and he said, how many young people? And I saw hands go up all over this theater of people who Olivia would agree, you are all very young, no matter what your age. And for those of you who are young, and I will define it, under the age of 25, say, I hope that if you don't know Olivia de Havilland's work, that this lecture will encourage you to watch her quite extraordinary films. Olivia is a woman of many, many incredible talents. It's true she has been recognized most often as an actress, as an actor, for her acting abilities. In Hollywood, really up until this day, she is universally recognized as one of the most beautiful women in Hollywood. She was naturally more beautiful by far than Vivien Leigh, who played Scarlett O'Hara in the famous Gone with the Wind. And in fact, the studio had to take measures to make Olivia look less beautiful so that she wouldn't compete with Vivien Leigh, who was supposed to play, and did play, the seductress Scarlett O'Hara in the movie. Olivia de Havilland has won 2 Academy Awards, as Tom told you, of course, for acting. One was for my personal favorite, The Heiress, which I'm going to show you a little bit of. She's received Emmy Awards as Best Actress. She's received Golden Globe Awards as Best Actress. She received the National Medal for the Arts by George W. Bush when he was president. And after she had been living in Paris for over 50 years, she received the Légion d'honneur medal by the French. So she has been recognized for her performances and her productions and her creativity as an actress all of her life. I want to tell you something that's not so widely known. She has significant ties with Oxford. Her father, Walter Augustus de Havilland, had the bad judgment to go to Cambridge University. Olivia was never close to him. Her paternal grandfather, the Reverend Charles de Havilland, had the good sense to go to Oriel College, Oxford. Olivia speaks warmly and with great pride of her grandfather. She made her amateur acting debut in 1933, and she played Oxford Lewis Carroll's Alice in Alice in Wonderland. But crossing the pond, Olivia is best known for her portrayal of Melanie Hamilton in Gone with the Wind. I think because of the immense popularity of Gone with the Wind and the fact that it's been shown in every country in all the world, and the popularity of Melanie as a character, that most people think of Olivia de Havilland as the woman that you see in the portrayal of Melanie. And Melanie is a woman who devoted her life to her man, Ashley Wilkes. His dreams were Melanie's dreams, and she was the support role. She was not the leader. Lovely but submissive. And I'd like to show you Olivia playing Melanie. And this is the Olivia that most of us best know.
So happy. You seem to belong here. As if it had all been imagined for you.
I like to feel that I belong to Remedies.
You love 12 Oaks as I do.
Yes, Ashley. I love it as more than a house. It's a whole world that wants only to be free don't you? But we don't have to be afraid for us. No war can come into our woman nation. Whatever comes, I'll love you just as I do now, until I die.
As much as we love the Olivia that in her portrayal of Melanie, as lawyers, we recognize another Olivia de Havilland. Olivia de Havilland, as Tom and Don said, who had the bravery to take on the studios. And that's the Olivia that we as lawyers honor here tonight. The Olivia who had the courage to take on Warner Brothers in court as a young woman with a career just starting. Now, Tom told you about Bette Davis, but the Bette Davis story is in striking contrast to the Olivia de Havilland story. Bette Davis ran away. Tom said she ran away to London to try to escape the tyranny of the studios. And she, Bette, got sued in London by the studios. Olivia de Havilland was the plaintiff in her case. She took on the studios in the courts. The task was enormously personally risky. It was professionally risky. Hollywood was dominated at the time, and some would argue still is today, by the studio executives and the heads of the studios. But there's another Olivia. The Melanie character does not, in my view, accurately portray the real Olivia, the Olivia who took on the studios. And I'm going to show you this clip, which is I'm doing in large part for Don and Tom, because this is the clip that all of you young men, youngsters in the audience, I think will remember if you're of such a certain age. This is Olivia, where she plays Maid Marian in Robin Hood, and Errol Flynn is the Robin Hood.
Yes, I am. Bitter. But it's a shame that I'm a Norman. I've seen the things my fellow countrymen have done to England. At first I wouldn't believe. Because I was a Norman, I wouldn't let myself believe that the horrors you inflicted on the Saxons were just and right. I know now why you tried so hard to kill this outlaw whom you despised. It's because he was the one man in England who protected the helpless against a lot of beasts who had brought down human blood. And now you intend to murder your own brother.
You'll be sorry you interfered.
Sorry. I'd do it again if you killed me for it.
So there's an Olivia full of fire and spirit. And she's a woman to take on the studios, as she took on Prince John in that clip. But now, as I promised, I'm going to show you my personal favorite Olivia de Havilland as she plays her Academy Award-winning role as Catherine Sloper in The Heiress. The Heiress was based on a Henry James novel called Washington Square. And Olivia plays the heiress who is rich, but not very pretty. She's dominated by a father who suppresses her. And then Montgomery Clift comes along as a fortune hunter, a very handsome fortune hunter, who tries to woo Olivia, Catherine, and it jilts her. 15 years later, he comes back. He's not made his fortune. He's not married a rich and beautiful wife. So he comes back to Olivia de Havilland. And here again is the strong Olivia, the woman who could take on anybody.
He came back with the same lies, the same silly phrases.
What are you saying?
He has grown greedier with the years. The first time he only wanted my money. Now he wants my love, too. Well, he came to the wrong house, and he came twice. I shall see that he never comes a third time.
Catherine, do you know what you're doing?
Yes.
Can you be so cruel?
Yes, I can be very cruel. I have been taught by masters.
And she was taught by masters. And those masters were men, and those masters were the men who dominated Hollywood at the time. Tonight, as lawyers, we honor Olivia for her contribution to the law. We honor her for her courage to do what was right against enormous odds. C.S. Lewis, who also taught at Lady Margaret Hall, who taught women students back in the day, said, "Courage is not simply one of the virtues. It is the form of every virtue at the testing point." And Olivia was tested. It was not easy to bring a lawsuit against the Warner Brothers studio at the time that she did, but she had courage. She had courage against odds. Bette Davis had lost. Tom said that the studios were looking over those contracts and documents, but at the time the case was brought, the odds were against a young actress being able to succeed in a lawsuit against the studios in a studio-dominated town. Our American Thomas Jefferson said, "One woman with courage is a majority." Okay, so he said one man with courage is a majority, but it's still true. It's still true nonetheless. Olivia de Havilland had the courage to try and change the law, and against the odds, she did. She very much regrets, Olivia does, that she could not be here tonight. If I can get this clip to come up, this picture to come up. Let's see. You doing it? No.
Get at the bottom.
Ross is telling me you're not doing this right.
Right at the bottom.
Hang on. I'm making it worse. Ross, where are you?
Double click on the picture.
Double click on the picture.
Somebody who knows about. Ah, there we go. Thank you. Thank you. Dawn and I were with Olivia in Paris last week. She very much regrets that she couldn't travel to be with you tonight. She would have loved to have been here. We are videotaping this so that she can see this presentation and see how warmly received she is, and her work and her mark on the law is with all of us. She very much gives you her best wishes for tonight. If she were here, I guarantee you she would drink champagne until the wee hours of the morning. And her final words to all of you are, please drink champagne in her absence. Drink her glass of champagne for her. And I hope tonight at Drinks we can all raise a glass to the wonderful, the marvelous, the eternally young, the inspirational, the courageous Olivia de Havilland. Thank you all.
Thank you, Suzelle and Tom. Principal, I think we do have 5 minutes or so, so if there is a question or two from the audience, I'll be happy to field those and call up some. Gary, we'll start with you.
I'm just interested in the implications of the perpetuity issue for copyright law. The big story these days is how Disney and all these other companies want to keep Mickey Mouse and other copyright images extended forever. And it seems to me that would go against the principle you were talking about. So
It does very much so. It is an exception to that principle, and for a limited number of years, although, as you know, it can be expanded and built on too. So it is, none of these principles are absolute, and copyright is a great example of another compromise to that. Interestingly, trade secrets can go on even longer. The most famous trade secret in the United States is, anyone know? The formula for Coca-Cola. And because they don't have a copyright or a patent on that formula, they don't have to disclose the trade secret, and as long as they can keep it a trade secret, they have protection to their trade secret. So these are not, as I say, the answer to the exam is not, no, you can't have perpetuities. No, they can't go on. They do go on, but they struggle against other principles in the law. In the case of copyright, it's the principle that you can't get a fair compensation to the people who create these things if you allow them to be knocked off immediately by others. So you give them some period of time. Like the 7-year rule in California, none of these are perfect compromises, but those are the principles they're struggling with. Very good question. The lady behind Gary, yes.
I was just wondering, obviously this had a big impact in the entertainment industry. Did it have a wider impact in fixed-term contracts in general, just for everyday people?
It's the law of all 50 states and virtually any civilized country today that you cannot have the specific performance of personal service contracts with exceptions. So everything is with exceptions, in this case the 7 years. So the principles at stake here are fundamental to the common law in the United States, in Great Britain, and it does have a significant impact. This case is cited repeatedly because the court in ruling not only said, no, we know how to count 7 years, but they explained the policy reasons behind it, and specifically that you couldn't, under the law, keep somebody's ability to reset the bargaining and get advantage forever. So yes, it's a very significant case beyond California and beyond Hollywood. In Hollywood, it ushered in the era of the free agency. And the reason that you see actors controlling their own destiny to the extent they can today is by and large thanks to Olivia de Havilland. There was another, yes sir.
Yes, in this country, if you have a point of law, you have to persuade a judge that you're on the right side. Do I infer from what you said that Mr. Havilland had to persuade a jury?
No, that's a very good question. So in the United States, we do have juries in civil cases. And in the right case, for example, if the issue had been the amount of damages under a contract, she would have been entitled to a jury for that. But on interpretation of contracts, on the interpretation of a contract, is a judicial issue in the United States. If there had been a full trial on damages, the judge still would have decided the interpretation of the contract. So it was decided by a single judge in the court below, and then by 3 judges on the Court of Appeals, and then it went up to, but was not decided. Certiorari was denied in our Supreme Court, and it became the law in California. But it was a judge question in the U.S. So one more, perhaps, for we have a historian of all this here. I'd like one for Tom, yes.
Forgive me, I wasn't going to ask a historical question.
All right, but ask ahead, ask ahead.
Okay, you touch in part on the clash between what the law says and what is perceived to be fair, in inverted commas, and I wonder, in practice, perhaps for both of you who are practicing attorneys, how much you find the courts are influenced heavily by issues of perceived fairness to challenge the boundaries of accepted legal interpretation.
It's a very good question, and one for the law students to take particularly to heart, because the claim of naked fairness, Your Honor, my position is fair, has to be, if not at the bottom of the barrel, way, way down in the barrel. You better have the principles of the cases lined up where some other court has determined that something is fair in a parallel or closely analogous situation. However, that having been said, as an overlay in arguing the cases, even to judges who I find much more fixed in their position than juries generally are in our country, they are not immune from the argument, if combined with the citation of authorities, that it is fundamentally unfair. But it should not be your leading argument. And standing alone, I wouldn't have, I'm sorry, Suzelle has a point on this. Suzelle has a point of precedence, and so I'm going to yield. Right?
No, it's an interesting comment on the fairness and also the issue about judge or jury. So we are dealing with human beings after all. So it is true that Olivia's case was tried with a judge, not a jury, and it was a matter of contract interpretation. But Olivia de Havilland testified. She testified to her state of mind and what she meant when she entered into the contract. And the judge, of course, was a man, and she was very much aware that it was an important role for her. So she has told me about her preparations for her testimony, how she rehearsed with her lawyer, how she wanted to wear the right outfit, properly demure, but not. She wanted to look attractive, and she very, very much knew that she was attempting to influence the judge on the question of what is fair. Yes, her lawyer gave the legal authorities, but Olivia herself testified. When they went to the appellate court, her lawyer and Olivia also recognized it was very important for her to be in the courtroom when the oral arguments occurred. And she told me last week in Paris, she said, I did notice that the judges looked at me and saw me come in and were paying attention, that I was in the courtroom when the justices of the Court of Appeal were listening to the legal arguments. So there's a human element to it, and again, thanks to Olivia for doing her homework and paying attention, and it wasn't just memorizing lines. She told me she read the statute herself, that she believed that the statute should be interpreted according to common sense in the way that she was setting forth, and that it was the right and the fair way. But I think they had a great advocate and a great spokesperson in that actress who played the leading role in the court.
I think with that, if you are like me, and I think Mr. Havilland would be at this time, your blood alcohol might be dangerously low. And we have a solution to that, I hope, so perhaps we can keep up the spirit of spirited discussion over drinks, and we would invite you all to join us for that purpose. But I want to thank the principal and the college on behalf of all of us for allowing us to come and being here. Thank you, Principal Lanning.
So I just want to thank our speakers tonight, Don and Tom and Suzelle, for these presentations. It's been informative and entertaining, as Hollywood should be, and inspiring. Some people make the law. Our panelists this evening study the law and practice the law, and I thought it was just delightful that all three of you have taken this opportunity to pay tribute to one lady who changed the law. So, a tribute to Olivia de Havilland, and a big thank you to our speakers. And I want to repeat Dawn's invitation to a reception in Talbot Hall. Thank you very much indeed.